Good morning or good afternoon, depending on where you are joining us from today. My name is Julia Ann Love, and I would like to welcome you to today's webinar. I am a partner and the practice group leader for the Employee Benefits and Executive Compensation practice of Thompson Hine. I'm joined today by Thompson Hine colleague Mark Kroboth from our Cleveland office and Lisa Miklich, a colleague from Chelko Consulting Group. Today, Mark, Lisa, and I will examine the new transparency and coverage requirement relating to machine-readable files and the new Consolidated Appropriations Act requirement relating to broker and consultant fee disclosures. This webinar is the third in a series of 6 Thompson Hine webinars presented the fourth Wednesday of every month at noon through August. Each webinar will explore a different Consolidated Appropriations Act related topic, including mental health parity, transparency, surprise billing, and more. Please join us monthly or just for the topics of interest to you. You can register through the invitation you received or on the Events tab on the Thompson Hine website. To proactively address a question we frequently receive, today's webinar is being recorded and will be sent to all registrants within approximately 2 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits. And now we will begin today's program. Session 3 and Session 4 of our 6-part webinar series will cover the Transparency and Coverage Rule and the transparency requirements of the Consolidated Appropriations Act. Today's presentation will cover machine-readable files under the Transparency and Coverage Rule and the broker and consultant fee disclosure rules under the Consolidated Appropriations Act, which were added to Section 408B2 of ERISA. Our second part on June 22nd, 2022, will cover additional requirements from the Consolidated Appropriations Act and the Transparency and Coverage Rule. And before I turn it over to Mark to discuss machine-readable files requirements, this slide shows where you can find each of the applicable transparency requirements and the applicable effective dates.
Thanks, Julia. So as Julia mentioned, I'm going to take a few minutes to discuss the transparency and coverage rule related to machine readable files, let everyone know what they are and what the requirements are. But before I get into that, I'm going to take a few minutes to talk about the background of the machine readable file requirements. So for plan year, initially for plan years beginning on or after January 1st, 2021, group health plans were responsible or needed to provide 3 different machine readable files. One machine readable file for in-network rates, a second for out-of-network rates, or sometimes called the allowed amount file, and then a third file for prescription drugs. So subsequent to the final rule being released, the Consolidated Appropriations Act was enacted, and due to that, implementation FAQ was released, FAQ 49 was released, and that essentially did 2 things, at least as far as machine readable files go. So the first thing it did was it delayed the prescription drug filing requirement, and the reason for that is because there's a requirement under the Consolidated Appropriations Act to provide certain information related to prescription drugs, and there was some overlap between that requirement and the machine readable file requirement. So as of right now, and the focus of this presentation will just be on the first 2 machine readable file requirements, the one for in-network files and the one for out-of-network files. And then the second thing that FAQ 49 did was it delayed the in and out-of-network file requirement to July 1st, 2022 for calendar year plans and plans that have the first day of the year is July or earlier. What it didn't increase, it didn't make earlier the requirement. So let's say you have an October 1st plan year, you will still need to provide those files beginning on October 1st, 2022. So now we're going to talk about the required information. As you see on the screen, the in-network file is essentially going to require negotiated rates for all covered items and services between the plan and the providers. But more specifically, you're going to have to essentially require 3 different items. The first thing is an identifier. And so you have to include a 14-digit health insurance oversight system number, or if you don't have one of those, there's a 5-digit number. and then if not, the EIN of the employer will be required. Secondly, the files are going to need to include billing codes, which will identify healthcare items or services for the purpose of billing, adjudicating claims, paying claims for each covered item or service. And some examples of these codes are CPT codes, diagnosis-related group codes, DRG codes. And then in addition to that, you'll also have to provide a plain language description for each of the codes. And then third, and possibly most importantly, you need to include the applicable rates. So there's various different rate structures that you might have with your in-network providers. So you're going to have to include, negotiated rates, any underlying fee schedules, or derived amounts. These amounts ideally will be reflected as dollar amounts with respect to each covered item or service that's furnished by an in-network provider. And you will also have to provide the national provider identifier for the provider, their tax identification number, and place of service codes for each of the in-network providers. For the out-of-network files, you have to include the same identifier information that you do for the in-network files and the same billing codes. But because out-of-network files, you're not going to have any, negotiated rates with these out-of-network providers, you're going to have to include unique out-of-network allowed amounts and bill charges for all services provided by out-of-network providers during the 90-day time period that begins 180 days prior to the date of publication. So by way of example, on July 1st, if you have a calendar plan and your due date is July 1st, 2022, the file that you're going to be providing is going to be from roughly the beginning of January and through that 90-day period. So it's essentially going to cover January, February, and March. The same information on providers, including the NPI and the TIN and place of service codes, will also need to be provided. There is one exception for out-of-network files, is that if an item or service has fewer than 20 different claims, the payment does not need to be included on the file. And then lastly, the prescription drug file, as I mentioned earlier, there's no due date right now. It's delayed pending further guidance. So I'm not going to go into the detail of what needs to be included. It's similar information as the in-network file and the out-of-network file, but related to prescription drugs. So a couple of additional considerations. Aggregation of data is permitted for the out-of-network amounts. So what that means is if you're working with your TPA, they're going to be able to aggregate various out-of-network amounts that come to them and that they adjudicate into a single file. And then secondly, for in-network information, it must be provided for each coverage option under the plan. So obviously a lot of plans have multiple tiers. You might have a high deductible coverage option, a PPO. Some plans have 3, 4, 5 different options. You're going to need to make sure that there is a file for each one of those options under the plan. So at this point, you're probably thinking there's no way you're going to be able to do this, and you'd probably be right if you're coming from a group health plan. And so what you're going to want to do is you're going to need to reach out, and hopefully you've already done this since the deadline is coming up very quickly. You're going to need to contact your TPAs, and you might want to amend your services agreement to allow them or require them to provide these services to you to create these machine readable files. If you have a self-insured plan and you do contract with a third party, you need to realize that the liability won't be shifted. Yes, you will be in a contractual relationship for them to provide the information, but if they don't, or if they provide the incorrect information, the group health plan is still going to be primarily liable for that. Whereas if you have a fully insured product, you can enter into a contract with your insurer to shift the liability and make sure that the insurer provides the required information, that it's the correct information, that it's provided timely. And so additionally, under the regulation, you'll be permitted to house the files on a third-party website. These files are massive files. So what we've seen so far is that TPAs will house this information on a link on their site, and then group health plans will be able to take that link and they'll be able to post it where they need to post it, and there'll be a little bit more on that coming up a little bit later. Okay. So the required format. Machine readable files must be publicly available, and they must be accessible to any person free of charge without conditions like a username or password or paywall. And I think there's been a lot of talk about this point about where do we want to put our link and where should we provide this information. I think a lot of group health plans do not have a website for the plan. If you have a website for the plan and it is publicly available and there's no username, no credentials that you need to get in there to see the information, then that's probably going to be your best bet. However, for plans that do have websites, a lot of them are password protected. You're putting your SPDs, your SBCs, you're putting your other annual notices that you need to provide on these websites, and so they're not publicly available. So putting the file link there is not going to comply with the regulation. So I think we're going to talk a little bit later about some things that maybe you can do to make sure you're complying and make sure that the link is in the right place. And I think the reason for this, for the machine readable files, I think it's important to note that it's not for participants, right? Participants, this information is going to be, these are massive files. They're readable by machines. They're not, you as a layperson are not going to be able to open up the file and understand what it says. The departments have noted that the files are really for researchers and data analysts to, quote, help drive additional price comparison and consumerism in the healthcare market. So it's not, at least not directly, there's not going to be a benefit to your participants. And then the information needs to be updated on a monthly basis. So every month you're going to need to go in, and if you have talked to a TPA and they've agreed to post the file on your behalf, you should be making sure that every first of the month that there's new information available. If you have the in-network file, the information that's newly posted, it might not be completely different. Some of the services that are being paid for under the plan or that are eligible to be paid for under the plan might not change. Your out-of-network file is likely going to change significantly on a monthly basis because the reporting, the 90-day reporting period is going to obviously move every month. And then lastly, on this required format, the files should be posted in JSON, XML, or CSV. The regulation does not state exactly which file you need to post in, but those are some examples of files that are acceptable. Excel files and PDF files are not acceptable. So at this point, you may be thinking, okay, how can I get out of this? I don't want to have to worry about this. If you are a grandfathered plan, I know there are very few these days, but if you are a grandfathered plan, you are going to be exempt from these requirements. If you have account-based plans such as HRAs or qualified small employer health reimbursement arrangements, you will not need to adhere to the machine readable files. And short-term limited duration insurance. A lot of group health plans are not going to be able to be exempt under these requirements, just based off the fact that they don't fall into one of these categories. So it just underscores how important it is to prepare for July 1st. So the last thing that I really want to touch on is this good faith reliance. And the regulation has a specific section that provides for this good faith reliance. So plans will not fail to comply if errors or omissions are corrected as soon as possible. So, I think it's not unreasonable to think that with all this data being posted that there might be missed data. You might have an item or service that you think maybe, or your TPA thinks is within the 20 person threshold, it's below it, and it actually isn't, and all these people have paid for this service and they haven't included it. As long as these errors are being corrected as soon as possible, you should be able to rely on the good faith reliance. Secondly, internet websites, if they're temporarily unavailable, they're not going to come in and penalize you for that. Obviously, websites go down quite often. It happens. And then third, you will not fail to comply if you have a good faith reliance on information provided by a third party, unless you know that the information is inaccurate. And just from a practical standpoint, you're probably, as a group health plan, not gonna know whether the information is inaccurate just by looking at these files. But if you do come across information that says either your TPA is using inaccurate information, you would have a responsibility to correct that information. And so I think at this point, you need to be making sure that on a monthly basis, the links are being updated at a minimum, because there's every 30 days or every first of the month, there's a requirement to post new information. I think that, from a group health plan standpoint, you should go in and click the link, make sure the information is different. It will be dated, so that you can make sure that your TPA is fulfilling their obligation and updating the files as they need to. So now I'm going to turn it over to Lisa, who's going to talk about some practical impediments that we've noticed.
Thanks, Mark. Appreciate it. I don't know about the rest of you, but I was sitting here thinking, gosh, I'm really glad that these files aren't meant for participants to read, because I've heard they're very nasty to see. And I was also thinking all these hoops we have to go through just so the researchers and data analysts can see what they should be able to get in the first place. But I just wanted to emphasize a few points, just some things that we're hearing from our clients, and as we're talking to partners like Thompson, Hine, things that are keeping our plan sponsors up at night related to machine readable files. So the first thing I want to emphasize is, I'm hoping, since 7/1 is right around the corner, that you have been having open dialogue with your TPAs about, their intent to help you comply with this rule. Mark mentioned that there's ability to rely on the TPA for providing this information, and in terms of a good faith reliance. And, one of the things you can do is just double check your service agreements and make sure that it's in there, that they are going to help you with this and provide the data that you need to rely on. And if you see that there's a gap there, maybe bringing that up to their attention and getting that remedied. I think the next thing is a lot of questions around what does publicly available mean to me as a plan sponsor, or how am I going to deal with that? And I think Mark spent a lot of time talking about that, but just a question to continuously ask yourself, can everybody get to this? Is this publicly available? Just taking that into consideration. Right now, for July 1st, it may not be the most natural place to put it. You may need to put it on, an investor page or something like that, because that might be the only place that you have that is publicly available at this time. And then, kind of keep in mind as this shakes out over time, or if, other guidance comes out and things like that, that you're nimble enough to make some changes. I think it seems, at least to us initially, it does always feel like the most reasonable place is to put it where you're putting everything else related to your benefits. But in this instance, that's not going to be compliant if you seemingly have to log in through an internet or what have you. So the next is just a question around, archiving this data. We've been getting this question a lot. We've been asking this question a lot. Some TPAs are surprised by this question, but I think it's, something to keep in mind. If you're posting the link, it's a big file, obviously, we know that, and multiple files, obviously, we know that now too. Do you have the ability to retain those every single month, or will your TPA who's providing this retain those every month for you? So just making sure you're, again, asking those questions too. And then, lastly, one of the questions that's coming up now is, you know, we've been talking to lots of TPAs about this, and you know, we've kind of exhausted a lot of the questions. They're ready. Most of them are ready to provide a file in some format that they think is going to meet these requirements. But one of the things that we're not getting a lot of traction on is, what about these additional vendors outside of the primary health plan? You know, we've seen a lot of movement on you know, a diabetes carve out or something like that. So you are participating in the health plan and you have an opportunity to take advantage of this diabetes management program. Is your TPA working together with that carve out solution to provide information in the machine readable file? If you haven't started asking those questions, you know, we think it would be a good idea to start engaging in that conversation to see if you can get your, you know, TPA to help you with that, or reach out to that carved out carrier and ask them what their plans are for July 1st. So that was kind of a new question that had come up that we wanted to bring up. And then another question that's not listed here that we think is really important, and we've been hearing a lot about that one too, is, as a plan sponsor, what is my obligation to communicate to participants, or is there any obligation to communicate that the files are ready or where they are? And actually, maybe this is good news. Maybe we end on a good news note here. There actually isn't an obligation to communicate it. You know, it's not in the rules. Maybe it's because they're really not meant for participants to use. They're not. This is not exactly something that you're going to be looking at to help make a better healthcare decision. So that's one thing you don't need to do. You just need to make sure you've got it publicly available on 7/1, but you don't need to communicate broadly that it's out there and available.
Okay, thank you, Lisa. Excuse me. We're going to turn now to a review of the broker consultant fee disclosures under the Consolidated Appropriations Act. So in short, the Consolidated Appropriations Act amended ERISA to provide that covered providers must provide compensation disclosures to covered plans. So breaking this down, who are covered service providers? We're going to talk a lot about this in a couple minutes, but basically covered service providers are vendors that provide brokerage services or consulting services. And who are covered plans? Covered plans are all group health plans, including accepted benefits, retiree-only plans, and grandfathered plans. When Lisa got here this morning, we were talking about whether this applies to like life insurance and disability, and the guidance, the amendments that were made by the Consolidated Appropriations Act make it clear that it only applies to group health plans. It does not apply to life insurance or long-term disability or anything like that. But when we get to the actual compensation disclosures, I'll explain why you might want to ask for it for those plans as well. And then when are the disclosures required? So the disclosures are required with regard to any agreements that are entered into or renewed after December 27th, 2021. So this would include amendments to existing agreements, so long as the amendment is executed after December 27th, 2021. So why does the Consolidated Appropriations Act require these broker consultant fee disclosures? You may recall that similar service provider fee disclosures are required for retirement plans, and this was effective back in July of 2012. And the idea is that for a planned fiduciary to determine whether a service provider's fees are commensurate with the services provided, and to ensure that there is no conflicts of interest, the fiduciary needs to understand and review and understand the compensation that the service provider is receiving as a result of the service provider agreement. But why is that important? And it's important because ERISA sets out a fiduciary obligation for planned fiduciaries, and also creates what's called prohibited transactions. And there is a specific prohibited transaction that arises when you have a service provider agreement with regard to furnishing goods or services or facilities between a plan and a party in interest. And the reason that that's a prohibited transaction is because it's considered self-dealing among the plan fiduciaries and the plan vendors. Of course, plans aren't able to operate if they can't have service provider agreements. And so the fiduciary structure of ERISA sets forth prohibited transaction exemptions. And so what the Consolidated Appropriations Act did was amend the prohibited transaction exemption under ERISA Section 408B2. And this amendment essentially requires these new broker consultant fee disclosures. Now, it's interesting to note that the requirements were added directly to the statute without any interpretation regulations. However, a field assistance bulletin was issued by the Department of Labor late last year, and I find it very interesting that the bulletin was issued after the effective date of the new guidance. So take that for what it's worth. But the field assistance bulletin provides that plan fiduciaries can use a reasonable good faith interpretation of the requirements and can take into account the DOL guidance on similar requirements for retirement plans, which, as I mentioned just a minute ago, were effective back in July of 2012. Excuse me. And I think for any plan fiduciary that also sponsors retirement plans, you're probably very familiar with these requirements. And the service providers are also very familiar with these requirements and pretty much routinely provide the disclosures if they're providing services that are subject to the requirements. So I think the idea or the Department of Labor's thinking on this and maybe interpreting what Congress meant when they amended the statute was that health plans will just fall in line and that they'll follow the similar process that's in place for retirement plans. So piecing this all together, we know that under ERISA Section 406, a prohibited transaction arises if there is an agreement between a plan and a party in interest to provide services to the plan, unless a prohibited transaction exemption applies. ERISA Section 408B basically provides an exemption if an agreement to provide services is for no more than reasonable compensation. However, the Consolidated Appropriations Act added this new provision that provides that no contract or arrangement for services between a covered plan, remember we talked about what a covered plan is, it's group health plans, including accepted benefits, retiree plans, and grandfathered plans, but not including life insurance or LTD plans, and a covered service provider. And remember, a covered service provider is one providing brokerage services or consulting services. And basically, this amendment provides that no extension or renewal of the agreement or contract is reasonable unless these new fee disclosure requirements are provided. And as I mentioned just a minute ago, it doesn't apply to life insurance or LTD plans, but the basic framework, we have a prohibited transaction under 406 if we have a service provider agreement with party in interest. An exemption applies if you pay more than, or if the services cost no more than reasonable compensation. So you still have that fiduciary obligation with regard to any ERISA plan. Retirement plans are subject to the fee disclosure requirement, and now group health plans are subject to the disclosure requirements. But don't forget your, plans that aren't in the covered service plan provision there. So what do covered service providers have to do if they're subject to this requirement? So covered service provider who reasonably expects to receive $1,000 or more in compensation, and included in that compensation is direct or indirect compensation, have to provide, this notice. And we're going to talk about what the requirements are. The field assistance bulletin clarified that fee disclosure requirements are required for covered services performed by and compensation received by not only the vendor with whom the contract is in place, but also affiliates and subcontractors of that vendor. And that brokers and consultants are not limited to those who are licensed as brokers and consultants, but instead includes service providers who perform brokerage and consulting services. So the million-dollar question is, what are brokerage and consultant services? So you'll see on this slide and on the next slide that we set forth what the definitions are of individuals who are providing, or vendors who are providing broker and consultant services. And to say that there's controversy about what this means is an understatement. So in short, a vendor who provides brokerage services is assisting with the selection of insurance products, record keeping services, medical management services, administration services, stop loss insurance, pharmacy benefit management services, wellness services, transparency tools, disease management services, compliance services, employee assistance programs, third-party administration services, and group purchasing organization preferred provider panels. So that's a mouthful. But essentially, for a broker or somebody who's performing brokerage services, they're helping with the selection of vendors that provide these various services. Flipping to the next slide, which entities are providing consulting services. So consulting services can include the development or implementation of plan design or insurance, or any of the services that were listed under the brokerage services. So again, insurance products, record keeping services, et cetera, et cetera. So now we know why the requirements apply, to whom the requirements apply. So what if a covered plan and a covered service provider enter into a new agreement or amend an existing agreement on or after December 27th, 2021? This is the gist of it. The covered service provider is supposed to provide a disclosure to the plan fiduciaries of direct and indirect compensation that they receive. And the statute says if a covered or a plan fiduciary of a covered plan does not receive the fee disclosure directly from the covered service provider, then they have to make a request for that fee disclosure. And if they don't receive it within 90 days, the covered plan is supposed to report that service provider to the Department of Labor. That's very draconian. And I think most plans and service providers, remember, they're partners with you. They don't, you don't necessarily want to be reporting them to Department of Labor. In addition, you have to make a fiduciary decision about whether you want to continue with that service provider providing services to your plan. And I'm sure most people that are listening to this webinar think that it's not the easiest thing to terminate a service provider and get a new service provider in place on the drop of a dime. So think about that. And then if the disclosures relate to future services, the fiduciary must terminate the contract or arrangement as expeditiously as possible. And remember, when I was going through the ERISA requirements, 406 and 408, it basically is a breach of fiduciary duty if you enter into a services agreement with a party in interest and the compensation for the services are not commensurate with the services, or they're not reasonable. And the statute says they're not reasonable if you don't get this fee disclosure. So I think the bottom line is the plan sponsor, the fiduciary, and the vendor all need to work together to make sure we're, coming to some sort of an agreement as to whether the vendor is providing brokerage services or consulting services, and whether a fee disclosure is required. From a practical standpoint, we've been, Thompson, Hine, and I'm sure Chelko as well, have been talking about these rules since they were enacted back in 2020, in December of 2020, and they became effective in December of 2021. But to date, I don't think there's a lot of agreement amongst the vendor community and the plan sponsor, plan fiduciary community as to what constitutes brokerage services and consulting services. And I think we're hearing a lot of pushback. I don't provide consulting services. I don't provide brokerage services. I just provide, adjudication services as a third-party administrator. Why do I have to provide these fee disclosures? And I think it's a very difficult position for plan fiduciaries to be in, because again, if you ask for the fee disclosure and you don't get it within 90 days, you're supposed to contact the Department of Labor and you're supposed to terminate the service provider's agreements. And we just talked about how difficult that is and how, unseemly that is. So, what are plan fiduciaries supposed to do? Well, in most cases, or, the rules are triggered if you have either a new agreement or you're amending a services agreement. So we would recommend, look at the services agreement. Does the services agreement otherwise already satisfy the fee disclosure requirements? So this slide kind of walks through what are the fee disclosure requirements. So the fee disclosure requirements are supposed to describe the services that are going to be provided pursuant to the agreement or the amendment to the agreement. More than likely, that's in your, the document that you already have. Additionally, the fee disclosure requirement, or the fee disclosure, is supposed to describe whether the service provider or an affiliate or subcontractor of the service provider reasonably expects to provide services as a fiduciary. And I would venture to guess that most of our services agreements already say we are a fiduciary, or we're absolutely not a fiduciary, or we're a fiduciary in only these very limited circumstances like adjudicating claims. So that's probably already in your agreement as well. The next requirement is that the fee disclosure describe direct compensation that the service provider, including its affiliates or subcontractors, reasonably expects to receive in connection with the services. And again, more than likely, this is already described in your services agreement. I think where we may come into some problems, and I think this is probably the rub of why service providers don't want to readily admit or readily label themselves as providing brokerage services or consulting services, it's because they don't normally disclose the indirect compensation that they receive as a result of the services that they're providing to a covered plan. And so my recommendation would be, again, if you're not getting a fee disclosure requirement upfront from your service provider, is to put into the agreement or the amendment to the agreement a representation from the service provider that they don't receive indirect compensation. And if the service provider is unwilling to provide that representation, then I think you can probe them and say, okay, then describe to me where you're getting, indirect compensation. How are you being compensated as a result of the plan receiving services from you as a service provider? And finally, the service or the fee disclosure, which can be part of your services agreement, has to describe the arrangement between the payer and the service provider or the affiliate or the subcontractor pursuant to which the indirect compensation is made. And again, I think this is a discussion with your service provider. Either they're not receiving indirect compensation, which many of them will say they're not. And if you probe them, maybe they'll say, they'll identify these sources. And if they do say that they're receiving indirect compensation, you can satisfy the requirements by having them identify, where the indirect compensation is coming from and what is the arrangement pursuant to which they're receiving the indirect compensation. And then finally, the fee disclosure or the services agreement has to describe the flow of compensation among the service provider, the affiliates, and the subcontractors, even if those amounts are already described in the direct or indirect compensation. And finally, the fee disclosure or the service provider agreement needs to provide a description of any fees that the service provider, including its affiliates or subcontractors, are going to receive in the event of termination of the contract. And this is important because it goes into the calculus of whether the total compensation that the service provider is receiving is reasonable with regard to the services that they're providing. As a reminder, with regard to fee disclosures, again, I think this will develop as a practice as we go along, like it has in the retirement plan world. You are required to receive a fee disclosure from a service provider reasonably in advance of the date on which the contract is going to be entered into, or reasonably in advance of the date of an amendment to a contract, as long as that is after December 27th, 2021. And again, the fee disclosure doesn't have to be a separate document. It can be part of your services agreement. So as long as you're negotiating the services agreement in advance of when the document is going to be entered into, or reasonably advances when the amendment is going to be entered into, this is not as big of a hurdle as maybe we thought it was. Also, they give some outs relating to, errors in the disclosure. So if a service provider finds out, that they didn't disclose a piece of indirect compensation, and they correct that disclosure within 60 days of when they find out that they're receiving this indirect compensation, there is no breach of fiduciary duty, and you're good with that. So, you want to have a partnership relation with your service provider so that they're knowing that if they didn't provide an accurate disclosure at the time you entered into an agreement or an amendment to the agreement, that they're providing that information as soon as they get it in their hands. And again, if there's an error or omission, I think I just said that before. So I'm sorry, the 60 days applies if there's a change in the information, and 30-day requirement applies if there's an error or omission. So there is some flexibility in getting the information from the service providers. And then the last thing I wanted to comment on is from the FAQs that were part of the FAB, the Field Assistance Bulletin. So I'm a fully insured plan with less than 100 participants. Do I need to comply? Yes. As I mentioned before, all group health plans are required to comply with the fee disclosure requirements, including accepted benefits. So, dental and vision plans or employee assistance programs, retiree-only plans and grandfathered plans have to comply. Do we need to reach out to service providers regarding existing contracts? And the answer is no. The requirements only apply to new agreements or amendments to existing agreements on or after December 27th, 2021. And then the last question answered by the FAQs were, when will regulations be issued? This is probably, to me, the most troubling answer of all, is that there's none expected. The statute, the Consolidated Appropriations Act, does not require the Department of Labor to issue regulations. And the Department of Labor's position is that these new requirements applicable to brokers or vendors providing brokerage and consulting services to covered plans mirror or very similar to the requirements that are applicable to retirement plans that have been in place for going on 12 years now. And so they don't feel that there's a need to provide additional regulations. I think I'd like to see additional clarification on, when is a vendor providing brokerage or consulting services? If the main service provided by a third-party administrator or PBM, for example, is adjudication of claims, are they a consultant because they're helping the plan sponsor to design the plan design for the benefit programs? I think a literal interpretation of the statutory language is that they are, but the vendor community pushes back pretty heavily on that. And I've spent a little bit of time addressing how you can push back on that or end run around that by getting the fee disclosure information into your services agreement. But I think it would be really helpful if the regulators would address that in a more detailed manner in any kind of future advice that they were going to issue. And to that point, the Department of Labor indicate that they are monitoring feedback from stakeholders. So hello, Department of Labor, I hope you're listening. I didn't see anyone on the list of webinar participants today, but if you're talking to your friendly local Department of Labor agent, if you could put that in their ear, I would appreciate it. And they're also they're monitoring their enforcement activities. So I assume that if you're under Department of Labor audit, they may ask about fee disclosures. And I also expect that if plan fiduciaries are reporting to the Department of Labor that they didn't receive a fee disclosure from a broker consultant or a vendor providing broker consulting services, that they will probe into that and potentially issue guidance addressing that. And with that, I'm going to turn it over to Lisa.
Thanks, Julia. Yeah, I think just to give a little bit of practical experience about, how does a plan sponsor make sure they're compliant with this part. And I think the best place to start is just an inventory of your providers. Take a good look at who's providing services for your group health plans, and do you think they reasonably fall under this category? And then I would start with looking at the service agreements and seeing if the things Julia went through are in them, and if you're in a current service agreement, and then really start just keeping track of do you need to get that amended and get those fees in there, and asking those questions and getting that done, so that you have a good sense of the due diligence that you've done to keep a handle on this. Because I do feel much like Julia said, we're getting a lot of pushback also from the vendor community, but I don't think that means we stop asking the question. I think it just actually makes me want to ask it more. You know, I don't know about your house, but in my house, when I say, you know, who finished the milk, everybody says, not me. And it's like, well, can't you just fess up to who finished the milk? So we're all on the same page here. And I think of this the same way. Why not tell your clients how much they're paying you for the service they provide? Seemingly they're providing you a service that you need, and there should be value associated with it. And I think it's a good question to be asking. And if they're not answering it, and you know, you're keeping track of all that, maybe you start to ask yourself, well, why aren't they telling us this, or how are they making money if this is
What do they have to hide?
right?
I think
exactly.
Excuse me, as the purchaser, the customer, I think it's a reasonable question to ask how much. I've never bought anything I didn't know what the price
Right.
was.
Exactly.
And how much money are you making as a result of my, you know, the plan that I'm a fiduciary of using your services? So, you know, even if there is no fee disclosure requirement, even if you can agree that the plan is not a covered plan, like the life insurance LTD question we talked about earlier, or, excuse me, the vendor is not providing brokerage or consulting services, you still have a prohibited transaction if you are not ensuring that the compensation received is reasonable for the services provided. So even before the Consolidated Appropriations Act made these fee disclosure requirements applicable to group health plans, fiduciaries should be asking that question, and vendors should be willing to answer the question.
Yeah, I agree completely. And I think it's just a really good practice to get into, asking those questions and holding everyone accountable for disclosing that information. You know, the other thing to keep in mind is, even though, I'm going to probably use the wrong word here, you know, the regulation says that it's actually the service provider's responsibility to disclose to you. You know, I'm not sure that's how it's going to go. You probably are going to need to prompt and ask. So just keeping track of that too, I think, is important.
Right. The statute says that it's the covered service provider's obligation to provide the disclosure, but it also puts the burden on the fiduciary to ask for it. So you as the plan fiduciary have an obligation to ask for the fee disclosure. And that's when if you don't receive it within 90 days, then you have you're between a rock and a hard spot. You either have to report to the Department of Labor that the provider, that the vendor that's providing brokerage or consulting services did not respond to your request to provide the fee disclosure, which I don't think anyone wants to be in that position.
Right, I agree.
So I think you either the plan fiduciary has to be comfortable that the service provider is not providing brokerage or consulting services, so they're not subject to the fee disclosure requirements. Or alternatively, like I said earlier, if they are providing those brokerage or consulting services, that your services agreement adequately addresses the elements that are required under the fee disclosure requirements. And just to reiterate them again, the services that are provided, is the service provider acting in a fiduciary capacity? What's the direct compensation received? And remember that the direct compensation includes compensation to the service provider, affiliates, and also subcontractors of the service provider. What's the indirect compensation that's being received, again, by the service provider, the affiliates, and the subcontractors of the service provider? What's the flow of indirect compensation, or what's the flow of compensation between the service provider, the affiliates, and the subcontractors? Even if those amounts were already disclosed in the direct or indirect compensation, there needs to be a discussion of how the compensation flows among the parties. And then also termination services, or termination fees, what kind of fees are you going to receive in the event that the contract terminates? So
yeah, and I think, really, if I was a plan sponsor, that's exactly where I'd start, is the service agreements. And I would take a good inventory of what's in them and what's missing.
And the good news is that this rule only applies to new agreements or amendments to agreements. And for those of you who were around in 2012 or who work with retirement plans, you had to get these fee disclosures for every agreement, not just new agreements. So at that time, it was a little bit more tricky because you had to enter into an agreement to amend the agreement if it wasn't already in there, if you had a service provider that wasn't providing the disclosures. In this case, because you're openly negotiating an agreement at this time or an amendment to the agreement, I think it's a little bit easier to get the information into the agreement now.
Yeah, I agree with that. And I think, Julia really touched on it quite a bit, that, the implications of the next steps of no response or delayed response are heavy for a plan sponsor. So I think, again, this idea that the whole community has to work together in this, the service providers, the brokers, consultants, and the plan sponsors, I think it's in everybody's best interest to work collaboratively to get this accomplished so that there aren't these draconian required responses to, a lack of providing it, or it's disruptive, it's disruptive then also to plan participants if there's got to be a quick, imminent change right away. So, just good motivation to work together to get the information that you need as a fiduciary.
Agreed. We have about 10 minutes left, and we would love to answer some of your questions in our remaining time. So if you have any questions, feel free to enter them in the, I don't know if it's a chat box, I forget what we called it at the beginning. Anyway, however you can answer yes questions in the chat. In the meantime, I will pose a couple of questions. So one thing we touched at the end of the machine readable files presentation was, what to do about point solution providers. So if you have a, carve out for, let's just say, centers of excellence or diabetes services or musculoskeletal services, how are you supposed to, or first of all, are those subject to the machine readable files requirements? And I think the answer is yes. As you may recall, the machine readable files requirement applies to each coverage option for in-network coverage. And so if the carve out or point solution is part of a coverage option under the plan, then presumably you need to integrate that with your machine readable file for in-network services. From a practical standpoint, I know our clients are not really seeing cooperation amongst the vendors and the point solutions providers. And I think that's something that will hopefully evolve over time. And hopefully we will see perhaps some additional guidance on how plan sponsors are to provide that information. And when you think about it from, what's the purpose behind the machine readable files? The purpose is to provide these data analysts with information about the cost of plan coverage and things, waste in the system that we can eliminate. And not to suggest that point solutions are waste, but presumably they're helping to lower the cost. And if we could see the integrated data, I think that would be helpful to the researchers. But I think we need to, like Lisa said earlier, we need the providers to work together to make that happen. And I do see we have some questions. The first one is, how can we get the slides? So anyone who registered for the webinar today will receive an email in a couple of days that will include both a recording of today's presentation as well as a copy of the slides. It'll come from Thompson Hine webinars, something like that, email, and it will include invitations to the remaining webinars that we have, which are, as I mentioned at the beginning, the June 22nd webinar is the second transparency presentation. Mark and I will be back to talk about some additional Consolidated Appropriations Act and transparency and coverage requirements. And we'll be joined by Austin Chelko of the Chelko Consulting Group for that webinar. And then in July, we have a webinar on surprise billing. And in August, we have a kind of wrap up to our 6-part series that will include lessons learned and questions and answers. So when you receive the next email from Thompson Hine webinars, you'll have the recording actually for the first 3 webinars and the slides, as well as invitations for the last 3 webinars. The next question is, are employers at risk of an ERISA fiduciary violation if the service provider does not provide the required disclosures? And the answer is yes. The ERISA, sets forth a fiduciary scheme pursuant to which plan fiduciaries must administer ERISA covered plans. And essentially, it is a prohibited transaction for a plan to enter into a services agreement with a party in interest for other than reasonable compensation. And the Consolidated Appropriations Act amended that provision to say it's not reasonable compensation unless you receive the fee disclosure. And like I said, I think reasonable minds can differ as to whether services provided are brokerage services or consulting services. But ultimately, if the fiduciary decides that the services are either brokerage services or consulting services, based on a reasonable good faith interpretation of the statute, there is an obligation to get the fee disclosure. And if you don't get it, you're required to make a request for it. And if you still don't get it within 90 days, then you have to report it to the Department of Labor and make a decision about whether you can continue, presumably with this breach of fiduciary duty. So it's a position you don't want to be in, and I strongly recommend that plan fiduciaries work with the third-party vendors to come up with a compromise. Maybe they don't want to say they're a brokerage or broker consultant, and that's fine. We don't have to parse hairs here. But if they're going to provide the information that satisfies the fee disclosure, I think we get to the same place. The next question is, are the machine readable files subject to ERISA's 6-year retention? I think there's more to that question, but I can't see it. But I think it's basically asking about the retention. Mark, do you want to answer that, or do you want me to?
You go ahead.
Okay. I would say that the transparency and coverage rule doesn't discuss records retention. I think it's a reasonable interpretation to say that there would be a requirement to maintain the records for 6 years. I think it's also a reasonable expectation that plan fiduciaries would maintain the records so that they can, on audit or in the event of a challenge, that they can demonstrate that they were compliant with the requirements. This to me seems like low-hanging fruit, and I can see plaintiffs' lawyers throwing it in there with, you didn't do X, Y, and Z that I was promised, and where's my machine readable file, even though they're not intended for plan participants. I think it's something to watch out for. And so as you're interfacing with the third-party administrators and others that are assisting in compliance with the machine readable files requirements, that would be something I would be asking, is the third-party administrator archiving these files? They're unwieldy and very large, and I expect that most plan fiduciaries do not want to have to utilize their cyber data storage capabilities for these files. I mean, and they're monthly, so they're ginormous files that are going to come out every month that you would have to maintain. So I think that's another area where it would be lovely if the regulators would give us some guidance on that. Do you think the obligation requires service providers to provide plan sponsors with the RX reporting information specific to their plan? I assume that means information relating to the prescription drug reporting. Prescription drug reporting was delayed. So the original transparency and coverage rule required prescription drug reporting by, I guess it was effective January 1st, 2022, and then was delayed to July 1st, 2022. But the FAQs that came out as a result of the Consolidated Appropriations Act further delayed that pending further guidance, because the Consolidated Appropriations Act similarly requires prescription drug reporting, which we're going to talk about on the June 22nd webinar. So I guess stay tuned for that. And then the last question that we can see right now is, can we get Ohio CLE for the program? And we did not apply for CLE credit, so it is not available for this program. Thompson Hine sponsors a number of programs that are subject to CLE, so if you're looking for CLE, you might want to look on the Thompson Hine website for other available programs. And that brings us to the top of the hour. So I would like to thank Lisa and Mark for presenting today, and to all of you attending our webinar. As mentioned earlier, we will send today's recorded webinar and slides to all registrants. I hope that you can attend one or more of the upcoming Consolidated Appropriations Act webinars. If you have questions we were unable to cover today, please reach out to your Thompson Hine attorney. If you aren't currently a client of Thompson Hine, please contact me or Mark, and we will be happy to discuss available options to address your needs. Thank you so much and enjoy the rest of your day.